Major update in the world of MCA loans. If you've watched our previous videos, you know that we hate these things. If you have questions about MCAs, we do a pretty thorough go through of them in a previous video we did a couple months ago. But the short version is they are predatory cash advances that come back to bite you with high interest rates and an addictive cycle of paying them off with more MCA loans over and over and over again. Good credit, bad credit, it doesn't matter. Just sign on the dotted line and your soul belongs to us. Now, the predatory side of what they do is something they get away with because of the terms that they use. MCAs are considered a merchant cash advance instead of a loan, so they're able to operate outside of the typical loan system that you might see from a bank or another lender. Until now. As fortune would have it, the MCA system has caught the attention of the bankruptcy court in the Southern District of New York, and the questions they are asking see through the smokescreen of terms these lenders have been using, and it might have a major impact on the future of MCA loans. Neil Goldstein is back to take us through the facts and give us an update on what's been going on and also what it may mean for you and other business owners who are sweating under a bad MCA loan. If you're new to the channel and like this kind of content, be sure that you subscribe so you never miss a new video. And with that, let's go to Neil. Neil, welcome back to the podcast.
Isaac, as always, it's a pleasure to speak with you and do this.
Well, this is more of an impromptu episode for us because you reached out to me letting me know that there are some updates that have happened in the MCA world, which is a big topic for us on the channel and a lot of what we talk about. But there have been some developments in the MCA world, and would you like to just fill us in on what the good news is?
There might have been a very important update on MCA loans that might help those struggling companies who have MCA loans and can't pay them.
So there's a distinction I want to make at the very beginning of this video, and you do a very good job of making this clear. There's a difference in the MCA world between a loan and an advance, which is how we understand they kind of skirt this whole legal question of how do they get away with this. Has that changed?
It hasn't changed yet, but it's moving in that direction, which is why I wanted to have this video so that people can understand what the changes are and how it affects them in a very, very positive manner. Before we get into this, I would like to do the following. I want to share the update, what the news means to companies who have MCA loans, and how management might be able to save their company from bankruptcy through the understanding of how the MCA advanced loan situation has changed.
So take us to the beginning. What is the big event that has caused this to come up again in conversation?
On August 6th of this year, 2025, Ben T. Nicholson wrote an article for ABL Advisor. It was entitled, Bankruptcy Court Knocked Some Teeth Out of MCAs. Summarizing the article as best as I can, the bankruptcy court in the Southern District of New York was analyzing merchant cash advance agreements under New York's legal standards. Their questions were to determine if MCA agreements were advances or loans. This is the question most professionals ask. The court applied several factors for consideration if the agreement was a loan or an advance.
This is an exciting moment for me, and Neil can attest to this. Whenever we talk about MCAs off camera, I'm usually frustrated that they exist. It doesn't seem fair. It seems like it's a predatory loan kind of situation. And it really seems like terms are starting to be redefined here as far as what is a loan versus what is an advance, if people are calling it one thing and calling it another. So why is it so important that it's called a loan or called an advance? They seem to be the same thing.
The big difference, Isaac, is that loans have rules, as we discussed before. Advances don't. Most MCA advances are somewhere between 60 and 90% interest, whereas a loan has to abide by usury laws. So it's a very big difference whether you call it an advance or a loan.
Okay. Does this article or this case potentially get rid of advance and classify everything as a loan, or is it going to make a distinction between the two?
I think the listener at this point should pay very close attention to what the court was trying to research and determine between a loan and an advance. If the court determines that it's a loan, then the company may have options with which to reorganize, remediate, and pay less to the MCA company. So pay close attention. I'm going to read the 5 factors that the court considered. 1, the MCA provider claimed that they would adjust payments if revenue dropped. Refunds on overcollections weren't enforced, and the provider was guaranteed payment regardless of performance. The court said that because the provider, the MCA company, bore no risk, it makes it a loan. Number 1, it's a loan. Factor number 2, despite the claim that the repayments were based on future sales, the provider, the MCA, knew the end date. The court determined that predictable payments and duration make it a loan. Check. That's 2 for 2. I'll take a short break to ask the listener, are either of these factors present in your transactions with an MCA? And I'll get to 3, 4, and 5 because I'm going to guess that all 5 may apply to a company's MCA loan. Number 3, personal guarantees. Personal guarantees, acceleration clauses, and enforcement rights are how lenders operate, not receivable buyers. The court said it's a loan. That's 3. 4, the business bank account was drafted daily regardless of sales, thereby taking priority on cash flow, making it a loan. That's 4. 4 checks, it's a loan. Number 5, the MCA provider regarded itself as a creditor in its own loan docs and claimed liens on all payments, not specific receivables. Could this be any more like a loan, the court asked? Check. All 5 factors were deemed that the MCA advance was a loan.
Now, does my MCA need to have all 5 of these to have that question in play? Or what if it's just maybe 1 and 3 that applies?
1 makes it a loan. Well, think of this. It seems the court came up with the old adage, if it walks like a duck and talks like a duck, it's a duck. Because there were so many factors that resembled a loan so closely, it can't be called an advance. So if a company has 1, 2, 3, if they have all 5, it compounds their ability to fight the usurious interest rate.
So what I'm hearing, and correct me if I'm wrong, it sounds like the court is at least defining what a loan is.
Correct. All of the court's findings continue what happened in New York in early 2025. The New York Attorney General won a $1.065 billion with a B judgment against Yellowstone Capital, permanently banning them from issuing MCAs, and get this, canceling over $534 million in debt owed by roughly 18,000 small businesses.
For those watching and listening at home, we're going to have links to all these studies and articles down in the show notes below, and we'll have them up on the screen while we talk about them. But let me ask you this. Does this change how MCAs are going to operate moving forward?
I don't think so, because we're at the nascent stage of this development. I've been dealing with MCAs for many years. They are very, very tough to deal with. They are providing a service that banks won't at the moment, and sometimes companies need that injection of cash flow. But I don't believe MCAs will change because they make too much money doing this. They're charging such significant interest rates, and they put pressure on people in companies who don't understand what we're discussing here today. Not everybody is going to see this video and hear what their options and possibilities are. And they get bullied. And the bullying leads to the company making payments. Until it becomes so prominent in the market and the MCAs start to lose money, will they change?
So let's break this down on a practical level. Let's say I'm one of the company owners that took an MCA loan and I wasn't covered in that 18,000 business group that had their debts erased. What does this news mean for me as a business owner with an MCA loan?
Well, it now gives companies a legal standing to reclassify their advances as loans. This is so important because of this interest rate, this usurious interest rate that the companies are paying to MCAs. So if a company recognizes it can change the interest rate from 90% down to, say, 25%, that's a significant amount of money to save. Also, they may be able to change the method by which they pay the MCAs, so it's not auto-drafted from their account each day or week. In essence, companies may be able to renegotiate their loans.
And that sounds like a complicated process. You know, a lot of business owners don't speak legalese. They don't know the first thing about going in and doing the work that it takes to take advantage of this legal standing they might have. So what would be the next step? How does someone get started in challenging their MCA loan or advance, into a loan?
Isaac, it's professionals. When I go into a client who, let's say, has been operating their business for 30 years, I can't tell them how to operate their company, but I know my business. So the first thing is to find the right professional. And it requires a good lawyer and a good CRO like me, at least I hope I am, to negotiate with the MCAs and explain to the business owner what is going to transpire. MCAs fight like the devil to get paid. So my recommendation would be reach out to somebody you trust, somebody who can find the right lawyer for you, who has experience working with MCAs. If a business owner wants, they could call me. I'll find the right people for them to fight the MCAs. Isaac, each case is different. I probably have worked on maybe 20 MCA cases. I've probably worked on over 30 MCA cases in the last few years, and no two were alike. And I say this because I know what my job is: to work on behalf of the client, to get reductions, settlements with the MCA company, but each of the MCA companies seems to be different. Their approach is different on collection. They litigate quick or slow. They negotiate well or hard. They continue to bully. There were so many differences in those 30 cases that it would be foolish of somebody to say there is one way to approach it. I highly recommend they call me. I'll listen to their story. I'll get them the right people to work on it.
Excellent. Well, Neil, thank you for coming on and giving us this quick update, and let's get some people some really good news.
Isaac, I implore the business owner to seek good advice to save their business, because if they can't, they're looking at bankruptcy. Just call and we'll get you some help. Thank you, Isaac.
If you have any additional questions about MCA loans or bankruptcy in general, feel free to reach out to Neil using the link down in the show notes below. You can reach out using our email or by giving us a call. Again, if you're new to the channel, be sure you subscribe so you never miss a new video. And with that, we will see you next time.